So now we'll be looking at the overview for criminal litigation. So when you hear criminal, what comes to mind? You know that we are talking about crimes, right? Offenses. But one thing you should know is that, which everybody should know, just the foundation. You don't need this, but for an act to be a crime or an offense, it means that it has to be stipulated in the law of that land. For instance, now marital rape, which is a very controversial topic or issue. As long as it is not in our law, no matter how you want to make it sound or seem, it is not in our law. It cannot be a crime here in Nigeria. So it has to be stipulated in the law that, this is a crime. And that's how you start talking about the criminal code, the penal code, the ACJA, the ACJA of various states. Now, what are the similarities between criminal and civil proceedings? The way we have criminal proceedings, we also have civil proceedings. They are not different. They are not just different. They also have similarities. Number one is the objective of serving justice. They both have the objective of serving justice. Number two, both trials are heard and determined in the courtroom. Number three, the judge who sits to hear criminal matters is the same judge who sits to adjudicate over civil matters. However, in some jurisdictions, like in Lagos, some judges, they are just assigned specific matters. For instance, where I did my externship last year, at ACJA High Court, my judge only sat on civil matters. She only heard civil matters. So students that wanted to hear criminal matters on our days where we were free, when our judge was not around or when court was not sitting, they could go to the criminal court to see how the proceedings went. But that's how it is. It could either be specific rules or together. Then we have the fourth similarity is the double jeopardy and res judicata rule. I mentioned these two because you use double jeopardy in criminal matters and res judicata in civil matters. It just means that double jeopardy is provided for in section 36 sub 9 of the 1999 Constitution of the Federal Republic of Nigeria. And it just means that for instance, now for double jeopardy, if an offender has been discharged and acquitted of an offense, you cannot charge the person back to court for that same offense that he has been acquitted and discharged for. Don't know if you understand. So that's just it. For instance, A was said to have committed, let me not waste time, but let's say, they said he stole something. However, at the end of the day, he was discharged and acquitted, right? So you cannot come and charge him again for that same crime. No, it's not possible. Same thing applies in civil proceedings. When either the court has found for the claimant or has dismissed the claim, you cannot reinitiate that proceedings in court concerning that same matter. So that's just it. Then what are now the differences? Because if there are similarities, definitely there will be differences between criminal and civil proceedings. You can take a look at the commencement. For every criminal proceedings, the proceeding is usually commenced by the state and is usually through the Attorney General. You can find this in section 174 and section 211 of the Constitution of the Federal Republic of Nigeria. So I might not have to be calling the full Constitution of the Federal Republic of Nigeria. I will just say Constitution just to save time. I don't want this video to be long. So you can also check the Police Act section 23. So, or any other person authorized or authority. But in civil proceedings, it could be by individuals, by a corporation. Then another difference are the parties. For criminal proceedings, the state is usually referred to as the prosecution, while the opposing party is the defendant. But in civil proceedings, the person that is commencing the action, that is bringing the action to court, is usually referred to as the claimant. And then the opposing party is the respondent. Don't mix it up, please. Then number three difference is the outcome of the proceedings. For a criminal case, at the end, the court will either, discharge and acquit the defendant or convict and punish. Those are the two that can happen. Maybe the person is innocent, we are hereby discharged and acquitted. But if the person is found guilty, he'll be convicted and punished. But at the end of a civil case, the court will either find for the claimant or dismiss the claim. That's the difference. Then you now talk about the body and standard of proof. In criminal case, the body of proof is on the prosecution and the standard of proof is beyond reasonable doubt. That's section 138 of the Evidence Act. While in civil cases, the burden of proof is on he who asserts. That's where you hear, oh, he who asserts must prove. You are the one saying, no, he did this, she did this. Okay, prove it now. You can find this in Section 135 of the Evidence Act. And the standard of proof is on the balance of probability or preponderance of evidence. Then we also have constitutional and statutory protection. In criminal trials, the accused person enjoys variety of legal protection. For instance, legal representation. You have the right to remain silent, right to speedy trials. But in civil trials, once the two parties are of age, they can represent themselves. But for criminal matter, if it's a capital offense, you must need a representative, a legal representative. Then another difference between criminal and civil proceedings is the giving of evidence. In criminal trial, an accused person may choose not to give evidence, and that one will not mean that the person is guilty. So his silence cannot amount to guilt. Is his rights or her rights. That one is provided for in Section 36 of the Constitution, 36 sub 11 of the Constitution, and Section 180 Evidence Act of the Evidence Act, I think, of 2011. This particular Section 180, I think it came out in our bar finals last year. I'm trying to remember this silence, that was silence amount. Maybe the person, they won't ask you straight question, no, it will be all in the scenario, the one that will determine. I can't really remember if it came out or if I was the one that practiced it myself during maybe past question or something. But I know this one, just pay attention and take notes. Everything is important though, don't get me wrong. Everything is important to law school. It is better to err on the side of surplus. Know everything. Better than not knowing some. Can be very painful. So it's better to know a lot so that when you ask any question, you'll be able to tackle it. So then that's why you have to start early so that you don't get pressured. Imagine learning 20 weeks topic. How do you're learning it from maybe after externship or close to exam. It's going to be really tiring, frustrating, exhausting, traumatizing. So yes, let's quickly go. Time is going. Sources of laws guiding criminal litigation. You have primary sources. And when you talk about primary sources, if you've not started already, you would have heard of ACJA, Administration of Criminal Justice Act, and then ACJA. That's for Lagos, or of Kano. There's of Kano, there's of Lagos. So those are the major laws you use in criminal litigation, except they will add some more. Then you cannot talk about secondary sources, the Constitution of the Federal Republic of Nigeria, 1999, the statutes creating courts. That's when you'll not be talking about the Federal High Court Acts, the Court of Appeal Acts, the Supreme Court Acts, all those high court laws. Then you also talk about rules of court, all those Federal High Court rules, State High Court rules, Court of Appeal rules, Supreme Court rules. Then we also have Police Acts. We also have Evidence Act of 2011. Then another source is practice and procedure. We have practice and procedure, talking about those application of English High Court procedure and practice in criminal matters. Then we have judicial interpretation. Okay, so this is already 8 minutes. Let's look at jurisdiction. So we to get a point, we will really talk about this, but we have Court of General Criminal Jurisdiction and Special Criminal Jurisdiction. So there's the General Criminal Jurisdiction, there's the Special Criminal Jurisdiction. For the General Criminal Jurisdiction, we have the customary court, area court, Sharia court, magistrate court. And do you know that even the General Criminal Jurisdiction is still divided into two? So the General Criminal Jurisdiction is divided into Court of Original Criminal Jurisdiction and Court of Appellate Criminal Jurisdiction. From the word appellate, you already know that they're talking about something high. So that appellate just consists of Court of Appeal and Supreme Court. Then the Original Criminal Jurisdiction, we're talking about customary court, area court, Sharia court, magistrate court, and high courts. So now we now have Special Criminal Jurisdiction. All these ones don't just go there anyhow. Federal High Court, National Industrial Court, Juvenile Court, Court Martial, International Criminal Court, Election Tribunals, Coroner's Court, Code of Conduct Tribunal. So these are the Special Criminal Jurisdiction. Then let's quickly move on to the setting of a criminal court. What's the setting of a criminal court? And this is one of the reasons why we go on externship. You will see the setting of the criminal court physically, not just on paper. But we have the bench. That's where the judge or the magistrate sits to address the court, to serve, to dispense justice. Then we have the bar. Those two bars. Usually there's the inner and the outer. The inner one is for the senior advocate, attorney general, while the outer one is for the other lawyers. So there's seniority at the bar, literally. Because for you to say there's the inner, you're already saying there's the inner, there's the outer. So you should know that there's seniority at the bar, even if we are all called to bar. Then there is the dock. That's where normally, usually, conventionally, the dock is supposed to be at the left side of the judge. I just know it like that, at the left side of the judge. Then the witness box is not conventionally supposed to be at the witness box. At the right side of the judge. But don't be surprised when you get to court and you see that it's the other way around. But just know this one, because this is academics. Don't try to argue, because academics is different from you trying to be a student's politician. I don't know how to put it. They're trying to say, oh, but this is how it's supposed to be. You're not concerned about whether this is how it's supposed to be or not. We're looking at academics. What have they said it to be? So when you finish, you can now be arguing those ones out. I don't know if you understand. So then we have the registrar's desk, the gallery. That's where the spectators, people that will come. Even during the externship, that's where you sit down. You sit down, you'll be watching the proceedings in the courts. Even lawyers too sit at this gallery. That's maybe if they don't have anything to do. Sometimes if there's no space, they can sit there too, because it depends on the courtroom, the size of the courtroom. Then sittings of the courts, like when the court sit, they sit Mondays to Sundays. So no superior court of record sit on juridical days. They're not supposed to sit on non-juridical days on Sunday. However, in Osasomi and COP, also take note of this case, Osasomi and COP, the court held that the court may subject to the agreements sit on non-juridical days. So usually you're supposed to sit on non-juridical days. So yes, non-juridical days. So it will now depend on the parties according to this Osasomi and COP. It will depend on the agreement of the parties. Like, if you want to sit on non-juridical days, like maybe Saturday, Sunday, public holiday, when the court is on vacation, you have to agree that, okay, we want to still sit here. You have to agree together. So, however, during because the judges have this annual vacation they go for, I think around July, August, there's still always a vacation judge in the High Court. So that one we hear emergency cases and matters that require urgency. So then in the magistrate court, at least one magistrate will always sit in every magisterial district for hearing cases of bail, remand, and other non-custodial dispositions. So, publicity of criminal trials, you can find this in section 36 sub 4 of the Constitution. So, if the trial is private, it can be held in the judge's chambers, but it could also be in the courtroom, provided that. So, when they say that it's private, there are instances where cases will be private. Usually they'll tell you that cases should be held in public, where people come inside and see how it is done, that yes, so justice has been served, the judge judged well. But then there are exceptions. This is found in section 36 sub 4 that I mentioned. Like, for instance, cases of juvenile matters, because you're trying to protect these children. Cases that involve state security, state issues. You can't just say anything like that to the public. They have to do with state issues. That one, you can find that one in section 191 and 192 of the Evidence Act. So these are exceptions to public hearings. So even if they are private, that they are private does not mean that it only has to be inside the judge's chambers. No, it can be in the courtroom, but only the parties. The doors will be shut against the public. Now, let's quickly go to the mode of dressing and decorum in the various courts. I might just brush through this because this video is already getting I was thinking maximum 10 minutes, but I'm sure you'd have seen that every part is important. Also, then, if everything is important, I don't want to tell you to just focus on this, focus on everything, because this mode of dressing too is something that comes up. So just know everything. God will help you. Yeah, so for customary and area court, so lawyer in customary and area court, lawyers don't usually go robed though. They don't go robed. But they can just be dressed in black suits, black shoes. It's not as serious as high court. And then even the judge itself is not as serious as high court. Down those ones they can wear any traditional apparel. Because even some of them they're not legally trained. Maybe they just know that those ones they have knowledge or wisdom in something. Say, yeah, come and be the judge. So they can wear anything for the judges. Then what about the mode of address? How do you address? In customary and area court, you address as your honor. Address the judge as your honor. Do you understand? Take note of all of these. Then in magistrate court, the dressing in magistrate court, because these people they're already qualified legal practitioners. I mean the lawyer. So, but they do not. These ones too. They don't have to also robe. You don't have to also robe, but they will be dressed in suits. They'll be dressed in suits. Then the mode of address is your worship. So what did I say? For customary and area court, you say your honor. In magistrate court, you will say your worship. However, in Lagos, so by virtue of section 349 of the Administration of Criminal Justice Law of Lagos State, you address as your honor. So magistrate court, in every other place you will say your worship, but in Lagos it is your honor. So what is the quorum? At least one magistrate will sit in every magisterial district for hearing cases of bail review and other custodial dispositions like I've mentioned before. You can find this in section 40 sub 2 of the Magistrate Court Law of Lagos State 2009. Now let's go to the High Court. We have seen customary and area court. We have seen magistrate court. What about High Court? Both the state and the federal. For the dressing, here the judge is robed because we are going higher now. The judge is robed. So a male judge should wear black suit, a white shirt, usually collarless or winged, plastic collar, stud and black shoes, wig and gown. A female judge would, wear a black skirt suit, white collarless, but the judge can wear a red gown. And when do they wear red gown? It is when they are trying a capital offense, and they are about to pronounce a death sentence. So once you enter, maybe during your externship now, maybe if you are in a criminal court and this particular day your judge enters with a red gown and a black cap, you will just know that day a sentence is going to be pronounced. I didn't experience this because I told you mine was a civil court. So but just know this. Then for a female lawyer, you must wear a black suit, a white collarless or ring shirt, a black pair of shoes, a white plastic collar, a bib, a stud, wig and gown. For a lady lawyer, a black skirt suit, a white blouse, a white collarette, black pair of shoes, wig and gown. So then the hairstyle shall not be in a wig form, as she is not expected to wear a wig on a wig. But in practice, we wear wig on wig. But just know this is academics, don't argue it. As a lady, you're not supposed to wear wig on wig. When I say wig on wig, now we wear wig and gown, right? So our lady wigs now, those wigs are usually wear now, all those fine wig, bone straight, raw donor, SDD. Usually, you're not supposed to wear your lawyer wig on top of that SDD, bone straight and everything. But that's just for on paper. Because I don't think they follow it. I've been to court many times during my externship. That's that. So privileges and seniority of senior members of the bar. So the wig of the judge is normally different from the counsel, and you see the judge having police orderly, all this police orderly. They don't go about alone. The material for lawyers' gown is cotton or mixed fiber gown. But for the senior members of the bar, talking about the Attorney General, the members of Body of Benchers, the Senior Advocate of Nigeria, they usually wear silk gowns. They are different. So the senior members of the bar, they sit in the front row, and they have the privilege of mentioning their cases before others. So even if your own case is number 1, once a senior advocate enters, and that senior advocate tone is number 10 or number 20, that senior advocate tone case will be mentioned before your own case. So their seniority is determined in the order of the Attorney General of Federation and then of the states, then the members of the body of benchers, then followed by the SAN. So it's like a hierarchy. So we have the AG Fed, AG States, body of members of the body of benchers, then the Senior Advocate of Nigeria. What is the mode of address? How do you address a judge in high courts, both in the state and federal? You will say, "My lord." What is the quorum? The high court is constituted by one judge sitting who is at least 10 years post-call. 10 years post-call. However, in the north, when the high court of states is hearing an appeal from the magistrates or upper area courts, 2 judges form the quorum to sit. You can find this in section 40 sub 1 of the High Court Law of Northern Nigeria. Everything here is important because you don't know which one will come out in your MCQ. And don't forget, this exam is both MCQ, 20 questions for MCQ, and then you have theory to fight for 80 marks. Let's move to the Court of Appeal. What is the dressing? So you must appear robed. I've already said the dressing, the suits and everything. So, but you will also appear robed. The mode of address, "My lords." Then the quorum, the court is constituted by at least 3 justices. This one, you find it in section 47. The Constitution, it provides for it. Section 247, sub 1. That is the quorum of the Court of Appeal. At least 3 justices. Or 5 justices by who are at least 12 years post-call. Each justice has a police orderly. 3 or 5. It is 5 when the matter has to deal with, like, it deals with constitutional interpretation. That's when there should be 5 justices, at least 5 justices with at least 12 years post-call. Get the difference. Then let's enter the Supreme Court. The dressing, they also have to be robed. Mode of address too, "My lord." My lords, because they're lords, "My lord," depend. If it's one, "My lord," if it's "My lords." But just know that for high courts, for Court of Appeal, for Supreme Court, "My lord." Mode of address, yes. Then the quorum. So this court, the Supreme Court, is constituted by at least 5 justices or 7 justices, 7 in constitutional interpretation or in the exercise of its original jurisdiction, who are at least 15 years post-call. So what are the ethical duties of counsel and courts in criminal trials? You cannot escape all these ethical. I think I would have mentioned it also in the property law overview that I did yesterday. I'm sure it would have been there. What are the ethical duties of counsel and courts in criminal trials? So the prosecuting counsel should be present in court at all times, to avoid forum shopping, act fairly, honestly and candidly, calling material witnesses, observing the interest of justice, conducting case with due diligence, making available to the accused person proof of evidence, avoiding frivolous institution of criminal proceedings. How about the defense counsel? Be present in court, undertake defense of an accused person, keep client confidences, don't withdraw from the brief, don't seek unnecessary adjournment. Some counsels can be very, very corny, or they can always try to play very smart. Seek unnecessary adjournment just to frustrate the whole matter. Then the defense counsel should also employ the right mode of address for the judge or other presiding officer of a court. Then don't cast aspersion on trial judge. Then what should the trial judge do? Grant to the parties right of audience before the court. Be neutral. Trial judge has to be neutral. Should not descend to the arena of conflict. Maintain high standard of conduct. Active participator in the proceedings but not necessarily interfere. Ensuring that litigants do not waste judicial time. Then the court registrar accept processes for filing, make records of proceedings available to the parties upon demand, ensure that hearing notices and other court processes are served, interpret or arrange for interpreter to interpret court proceedings to an accused if necessary. You will see all these things by the time you go to court. You see them live and direct. Ensures that the court file is brought to the attention of the judge before the date for hearing, especially when a new process is filed by a party. Then in a capital offence where the accused is sentenced to death, the registrar shall, as soon as possible, forward copies of the certificate issued by the judge to the prison officer as well as the sheriff. Generally, he liaises between the court and the AG in issues of plea of clemency in capital offences. So that's just it. Just have knowledge of those ethical responsibilities of counsel and judges in court. So with this, we'll come to the end of the overview of criminal litigation. Drum rolls. If this has been helpful to you, share it with your other friends in other campuses, subscribe, turn on notification bell so that you can always get notified whenever I post a new video. Thank you. And yes, before I forget, I have to add this next video, be looking at someone's arrest and searches. So looking at them, and then that's when I start talking about little drafts. We start analyzing some drafts. Don't worry, I'll add the drafts because I have my drafts. I can be adding the pictures of my draft to it, or maybe I'll even recommend the draft book that I got. I also bought a draft book while in law school. I use it alongside some other materials, but I have to be very careful because, and also pay aside those draft book and those ones in those online, not online now, those materials. I'm trying to remember, is it Condi Smith, all those ones, Agbata, all aside those ones, make sure you pay attention in class because there are corrections they will make in class. While if a lecturer is, doing the draft with you, there are corrections they will make in class that because it's academics, it will be different from the one that will be inside those draft book or inside the one that is in your materials on your phone. I don't know if you understand. So pay attention to little details, all those details. Pay attention, and that's why you have to go back that same day to make your note and draft it out. Because once you get the correction, keep it in your head, jot it out, go back to your hostel, library, draft your own so that you have the correct draft with you. Because if you say you want to wait till later, I'm telling you, are going to forget the correction that was made in class. No jokes. Thank you.